The federal courtroom was packed, the kind of packed that makes even seasoned reporters stand on tiptoe and law students squeeze into the aisles. The air was thick with anticipation, the kind that only comes before a moment everyone senses will be replayed for years. At the center of it all sat Judge Beryl Howell, a formidable presence on the bench. Her reputation for razor-sharp intellect and little patience for what she deemed speculative arguments preceding her, she was the old guard, appointed by President Obama. Former Chief Judge of the D.C. District Court, and a legal mind who had seen it all. But today, the room wasn't just filled with lawyers and journalists, it was filled with something else. The possibility of a generational shift. Because standing at the podium, notes perfectly organized, was Congresswoman Jasmine Crockett. At 43, she was already a rising star in Congress. Known for her viral moments and her ability to turn legalese into plain English, she'd built her career as a public defender in Dallas, fighting for clients who couldn't afford a voice. And now she was here, in one of the most intimidating courtrooms in America, ready to argue a case that could change the way voting rights are protected for a generation. Crockett's argument was bold. She called it the algorithmic justice doctrine, the idea that constitutional protections for voting rights must evolve with technology, not remain frozen in the language and prejudices of the 20th century. She'd spent months preparing, poring over Supreme Court precedents, building a case that wove together the 14th and 15th Amendments with the realities of modern digital systems. Her supporters in the gallery, civil rights advocates, law students, and a handful of skeptical legal scholars, watched with a mix of hope and anxiety. Judge Howell listened, her expression unreadable. She was known for her technical brilliance, but also for her impatience with what she considered trendy legal theories. As Crockett spoke, Howell's eyes narrowed, her pen tapping a steady rhythm on the bench. Still, Crockett pressed on, citing Anderson v. Shelby Reynolds v. Sims and the recent Arizona redistricting case. Her logic was clear, her citations precise. In any law school classroom, it would have been a master class. But this wasn't a classroom. This was Howell's courtroom, and she was about to remind everyone of that fact. When Crockett finished her opening, the silence was electric. Howell leaned forward, elbows on the bench, and fixed her with a stare that had made more than one attorney wilt. Then, in a move that would be replayed on every news channel in America, she laughed. Not a polite chuckle, but a full, dismissive laugh that echoed through the chamber. The sound was sharp, almost cruel, and it cut through the tension like a knife. The gallery gasped. Reporters' fingers flew across keyboards. Even the court reporter paused, unsure whether to record the laughter as part of the official transcript. Howell shook her head, still smiling. "Congresswoman Crockett," she said, her voice dripping with condescension, "are you seriously suggesting that this court should compel the government to produce technical modules based on your algorithmic justice theory? That sounds more like a conspiracy theory than a legal argument." The question hung in the air, heavy and loaded. Crockett paused, her face unreadable. She'd faced hostile judges before, but this was different. This was a public challenge, a dare to defend not just her argument, but her credibility, her motives, her very place in the legal world. She took a breath, steadying herself. The room was silent, every eye on her. Then, instead of flinching, she smiled. A calm, confident smile that seemed to catch Howell off guard. "Your Honor," she began, her voice steady and clear, "I appreciate your question, because it gives me the opportunity to address something that I think has been bothering you throughout this entire presentation." She paused, letting the words settle. Howell's smile faded, just a little. "You've been treating me like a politician playing dress-up as a lawyer. But with all due respect, Your Honor, I think you've forgotten something important about my background." She reached into her briefcase and pulled out a thick folder. The movement was deliberate, controlled, like a chess player making a move she'd planned 10 steps ahead. "Before I was elected to Congress, I spent 12 years as a public defender in Dallas County. I handled over 500 cases. I argued before the Texas Court of Appeals 47 times. I won 38 of those appeals." A murmur rippled through the gallery. Howell's expression shifted, just slightly, from amusement to curiosity. But more importantly, Your Honor. I argued a case very similar to this one before the Fifth Circuit Court of Appeals in 2019. The case was Williams v. Texas Secretary of State. And I won. She placed a copy of the decision on the podium. In that case, I successfully argued that voting rights protections needed to be interpreted in the context of modern democratic participation. The Fifth Circuit panel, in a unanimous decision, agreed with my interpretation and overturned a lower court ruling that had used the exact same narrow constitutional interpretation that you seem to prefer. The silence in the courtroom was now total. Reporters scrambled to look up the case on their phones. Howell's face was unreadable, but the shift in the room was palpable. Crockett wasn't finished. She pulled out another document, this one clearly an official court filing. Your Honor, I've also taken the liberty of researching your own judicial record on voting rights cases. In the past 5 years, you've heard 14 cases involving voting rights challenges. You ruled against voting rights protections in 13 of those 14 cases. In 11 of those 13, your decisions were either reversed on appeal or the parties settled before appeal because your interpretations were considered legally unsustainable. A collective gasp swept the gallery. Attacking a federal judge's record in her own courtroom was almost unheard of. But Crockett's tone was respectful, her delivery precise. Howell's jaw tightened. "Congresswoman Crockett," she said, her voice now carrying a warning tone, "you're treading on very dangerous ground." Crockett met her gaze, unflinching. "Am I, Your Honor? Or am I simply doing what every good lawyer should do, presenting facts and legal precedent to support my argument?" The room was silent, the balance of power shifting. Crockett had just turned Howell's laughter into a challenge. She was just getting started. Howell's warning seemed to hang in the air, but Crockett pressed forward, her voice unwavering. "The fact is, Your Honor, that my algorithmic justice doctrine isn't some radical new theory invented for political purposes. It's rooted in established Supreme Court precedent going back to Baker v. Carr in 1962, fined through Reynolds v. Sims, and most recently supported by the courts. Decision in Arizona Legislature v. Arizona. Independent Redistricting Commission, she began citing cases with the rapid-fire precision of someone who had spent years mastering constitutional law. Each citation was accurate, each reference directly supported her argument, and each example demonstrated a level of legal scholarship that was impossible to dismiss. Furthermore, Your Honor, the so-called conspiracy theory you accuse me of has already been validated by 3 different federal appeals courts in the past 18 months. The Ninth Circuit in California, the Fourth Circuit in Virginia, and yes, the Fifth Circuit in Texas have all recognized that voting rights interpretations must evolve with democratic understanding, especially when technology is involved. As Crockett continued, the energy in the courtroom shifted. What had started as a dismissive judicial smackdown was becoming something else entirely. Even the most skeptical legal scholars in the gallery began to take notice. Howell, for her part, leaned back in her chair, her earlier confidence replaced by a more measured, almost cautious demeanor. Your Honor, Crockett continued, you asked if I really believe my theory has legal merit. Let me answer that directly. Not only do I believe it has merit, but I'm prepared to demonstrate that the legal theory I'm presenting today is more solidly grounded in constitutional precedent than the narrow interpretation that has led to your reversals on appeal. She pulled out one final document from her folder, this one bound in the distinctive blue cover of a Supreme Court filing. 6 months ago, I filed an amicus brief with the Supreme Court in the case of Morrison v. Alabama. That brief presented the same algorithmic justice doctrine that you've dismissed as a conspiracy theory today. She paused for effect, and the silence in the courtroom became almost oppressive. That amicus brief was cited favorably by Justice Barrett in her majority opinion, which was joined by Chief Justice Roberts and Justices Kavanaugh, Gorsuch, and Thomas. The Supreme Court of the United States, Your Honor, with a conservative majority, has already validated the legal theory that you've spent the last hour mocking. The impact of this revelation was immediate and devastating. Howell's face went through a series of expressions, surprise, concern, and what looked like the beginning of regret. Several people in the gallery audibly gasped. The reporters in the room were frantically taking notes, knowing they were witnessing something that would dominate legal news for weeks. What made Crockett's response even more powerful was that she delivered it with complete respect for the court and the judicial process. She never attacked Howell personally, never raised her voice, and never showed disrespect for her position. "Your Honor," she said, closing her folder and looking directly at the judge, "I didn't come to your courtroom today to create political theater or to advance my career. I came here because I believe that voting rights are under attack, and I believe that the Constitution provides tools to protect those rights if we're willing to interpret it with the wisdom and flexibility that the founders intended." She paused, and for the first time in the entire exchange, her voice carried a note of emotion. "I spent 12 years defending people who couldn't defend themselves. I've spent 2 years in Congress fighting for policies that protect ordinary Americans. And I'm here today because I believe that the legal theory I'm presenting can help protect the fundamental right that makes all other rights possible, the right to vote." The courtroom remained silent, but the energy in the room had completely shifted. What had started as a dismissive judicial smackdown had become something else entirely. Howell sat back in her chair. Her earlier confidence completely evaporated. She removed her glasses again, but this time it wasn't a gesture of condescension. It was someone trying to buy time to process what had just happened. "Congresswoman Crockett," she said finally, her voice notably different from the dismissive tone she had used earlier, "I think we should take a brief recess to allow me to review. Some of the cases you've cited was as close to an admission of error as anyone had ever heard from Howell in her years on the bench." But Crockett wasn't quite finished. "Of course, Your Honor, and when we return, I'd be happy to provide copies of all the appellate decisions that have validated this approach, including the 3 cases where similar legal theories were specifically endorsed by judges who had initially expressed skepticism similar to what you've shown today." The message was clear. Other judges had made the same mistake Howell was making, and they had been forced to acknowledge their error. As the judge called for a 15-minute recess, the courtroom exploded into excited conversation. Legal observers were already pulling out their phones to start researching the cases Crockett had cited, while reporters began writing stories about what was clearly going to be a major legal news story. Howell stepped down from the bench and disappeared into her chambers, leaving behind a courtroom full of people who had just witnessed something unprecedented. A sitting member of Congress had systematically dismantled a federal judge's dismissive attitude using nothing but superior legal scholarship and unshakable confidence. When Howell returned to the courtroom after the recess, she was a changed woman. Gone was the condescending confidence that had marked her earlier questioning. In its place was the careful demeanor of a jurist who had just realized she had made a significant error in judgment. "Congresswoman Crockett," she began, her voice notably more respectful, "I've had an opportunity to review some of the cases you cited, and I want to acknowledge that your legal scholarship appears to be more thorough than I initially recognized." The admission sent ripples through the courtroom. For a federal judge to acknowledge error in such a public way was almost unprecedented. Legal observers in the gallery exchanged knowing glances. They were witnessing legal history. "While I may still have concerns about some aspects of your constitutional interpretation," Howell continued, "I want to apologize for suggesting that your arguments were motivated by political considerations rather than legal scholarship. That was inappropriate, and it was wrong." The apology was delivered in the formal language of the courtroom, but its impact was unmistakable. Crockett had not only defended her legal theory, she had forced one of the most respected federal judges in the country to publicly acknowledge her mistake. Within hours of the hearing, legal Twitter exploded with commentary about what had just happened. The video of Judge Howell's dismissive laughter, followed by Crockett's systematic demolition of her position, spread like wildfire across social media. Professor Sarah Chen from Stanford Law who had been critical of Crockett's theory in her amicus brief, tweeted, "Regardless of one's position on the algorithmic justice doctrine, what happened in Howell's courtroom today was a masterclass in legal advocacy. Crockett came prepared for every possible attack." Harvard law professor Michael Rodriguez added, "I've been teaching constitutional law for 20 years, and I've never seen a more effective courtroom response to judicial hostility." Crockett turned what should have been her destruction into Howell's education. The National Association of Criminal Defense Lawyers issued a statement praising Crockett's performance. Representative Crockett demonstrated today why she was such an effective public defender. She came to court prepared, stayed calm under pressure, and let the law speak for itself. A prominent appellate attorney who had argued before Howell multiple times tweeted, "I've seen Judge Howell destroy attorneys who were far more experienced than Crockett. What she did today was legendary. She turned the courtroom into her classroom." The political world was quick to react to the viral video of the hearing. The contrast between Howell's dismissive laughter and Crockett's calm, fact-based response created exactly the kind of moment that dominates political news cycles. House Democratic leadership immediately seized on the moment as an example of why diverse voices matter in government. Speaker Nancy Pelosi tweeted, "Representative Crockett showed today why we need leaders who understand both the law and the real-world impact of judicial decisions." Congressional Black Caucus Chair Joyce Beatty added, "This is what happens when you underestimate a black woman who knows her stuff." Jasmine Crockett came with receipts, and she delivered them with class. Interestingly, even some Republican legal experts acknowledged the effectiveness of Crockett's performance, though they remained critical of her underlying legal theory. Senator Ted Cruz, himself a former Supreme Court clerk, tweeted, "I disagree with Representative Crockett's constitutional interpretation, but her advocacy skills were impressive. This is what happens when politicians actually understand the law they're trying to change." Progressive organizations and activists celebrated the moment as a victory for both voting rights and for the principle that establishment figures shouldn't dismiss new ideas without serious consideration. The ACLU tweeted, "This is what fearless advocacy looks like." Representative Crockett didn't just defend her legal theory. She defended the principle that constitutional interpretation must serve justice, not just tradition. Major news outlets struggled to categorize the story. Was it legal news? Political news? A viral moment? In the end, it became all three. CNN legal analyst Jeffrey Toobin called it one of the most effective pieces of courtroom advocacy I've seen in decades. He noted that Crockett had managed to turn a hostile judicial environment into a platform for demonstrating legal expertise. MSNBC's legal commentators focused on the broader implications for voting rights cases, with Rachel Maddow dedicating an entire segment to explaining how Crockett's theory could affect future election law challenges. Fox News took a more measured approach, with legal analyst Andrew Napolitano acknowledging that while he disagreed with Crockett's constitutional interpretation, her legal scholarship was undeniably impressive. The New York Times published a lengthy analysis of Crockett's legal background, noting that her success as a public defender had prepared her for exactly this kind of hostile questioning. The Washington Post focused on the broader implications for the federal judiciary, questioning whether judges like Howell were too quick to dismiss legal theories that challenged established precedent. Legal publications like Law 360 and the National Law Journal provided detailed analysis of the cases Crockett had cited, confirming that her legal research was accurate and her citations were properly used. Law schools across the country immediately began incorporating the hearing into their curriculum. The exchange between Crockett and Howell became a case study in effective advocacy under pressure. Yale Law School announced that they would be hosting a symposium on constitutional evolution and judicial bias, featuring the Crockett-Howell exchange as a central case study. Harvard Law Review published a lengthy analysis of Crockett's legal theory, concluding that while reasonable people could disagree with her interpretation, her scholarship was rigorous and well-grounded in precedent. Several law schools invited Crockett to speak about her experience, leading to a series of lectures that further elevated her profile in legal academia. The hearing had a profound impact on Judge Howell's approach to her judicial duties. Legal observers noted that in subsequent hearings, she was notably more careful about dismissing arguments that challenged conventional legal thinking. In a voting rights case heard 3 weeks later, Howell took pains to carefully consider novel legal arguments rather than dismissing them outright. Legal commentators noted the stark difference in her approach. Fellow judges on the D.C. District Court privately acknowledged that the Crockett hearing had served as a wake-up call about the dangers of judicial arrogance. In a rare interview with a Legal Affairs magazine 6 months later, Howell reflected on the hearing. Representative Crockett taught me that experience and wisdom aren't the same thing. I allowed my experience on the bench to make me close to new ideas, and that was a mistake. Perhaps most importantly, Crockett's performance in Howell's courtroom gave new credibility to her algorithmic justice doctrine and similar approaches to constitutional interpretation. Within 6 months, voting rights advocates in 12 states had filed motions incorporating elements of Crockett's legal theory. 3 federal appeals courts agreed to hear cases that specifically addressed the constitutional questions she had raised. And the Supreme Court granted certiorari in a case that would directly address whether voting rights protections should be interpreted in the context of modern democratic participation. Exactly the question Crockett had been arguing. What had been dismissed as political theater by establishment, legal figures, was increasingly being taken seriously by constitutional scholars. Law review articles began exploring the theoretical foundations of Crockett's approach, lending academic credibility to her arguments. The viral hearing transformed Crockett from a relatively unknown House member into a national figure. But more importantly for her, it validated her decision to bring her legal expertise to Congress. Within Congress, Crockett's stock rose dramatically. Colleagues who had seen her as just another freshman representative began seeking her input on legal matters. She was appointed to key committees and became a go-to voice for Democrats on constitutional issues. The hearing reestablished Crockett's credentials as a serious legal mind. Prestigious law firms began reaching out about potential partnerships, and legal organizations invited her to speak at major conferences. Talk of Crockett as a potential Supreme Court nominee or state attorney general began circulating in political circles. The hearing had demonstrated that she possessed the intellectual firepower and courtroom presence necessary for higher judicial office. Beyond the immediate legal and political implications, the Crockett-Howell exchange became a cultural moment that resonated far beyond the legal community. The hashtag #CROCKETTV Howell trended for days on social media. Memes celebrating Crockett's performance flooded Twitter and Instagram, many focusing on the contrast between Howell's initial dismissive laughter and her eventual respectful apology. TikTok users created dozens of videos breaking down the legal arguments for younger audiences, helping to educate a new generation about voting rights and constitutional interpretation. Young lawyers, particularly women and people of color, cited the hearing as inspiration for their own careers. Law school applications from underrepresented groups increased. In the months following the hearing, public defender offices reported increased interest from law graduates who had been inspired by Crockett's background and her effective advocacy. Perhaps most importantly, the hearing served as a masterclass in legal advocacy that continues to be studied and analyzed. Law schools now use the hearing as an example of how to respond to hostile questioning. Students learn from Crockett's calm demeanor, thorough preparation, and strategic use of legal precedent. Advocacy training programs for young lawyers incorporate the hearing into their curriculum, teaching the importance of research, preparation, and confidence in high-pressure situations. The hearing helped educate the general public about voting rights law and constitutional interpretation. Complex legal concepts became accessible through the dramatic narrative of Crockett's response to judicial dismissal. The Crockett-Howell hearing represents more than just a viral moment or a legal victory. It symbolizes a changing of the guard in American legal and political culture. The hearing highlighted the tension between established legal thinking and new approaches to constitutional interpretation. Crockett's success demonstrated that fresh perspectives and rigorous scholarship could challenge even the most entrenched judicial attitudes. The hearing sparked conversations about judicial training and the need for federal judges to remain open to new legal theories rather than dismissing them based on preconceived notions. Most fundamentally, the hearing advanced the cause of voting rights by lending credibility to new approaches to constitutional protection of democratic participation. What happened in Judge Howell's courtroom that day teaches us something important about American democracy and the legal system that supports it. When Jasmine Crockett walked into that courtroom, she represented more than just a legal theory or a political position. She represented the principle that good ideas and rigorous scholarship can triumph over institutional bias and entrenched thinking. Judge Howell's initial dismissive laughter represented the worst impulses of an established system that too often values tradition over justice and experience over innovation. But her eventual apology and respectful treatment of Crockett's arguments showed that even the most entrenched institutions can change when confronted with superior preparation and unshakable conviction. The viral nature of the hearing, the way it captured public attention and sparked national conversation, demonstrates the power of dramatic moments to educate and inspire. Millions of Americans learned about voting rights law, constitutional interpretation, and effective advocacy by watching Crockett systematically dismantle Howell's condescending attitude. But perhaps most importantly, the hearing showed that in America, ideas still matter more than titles. Preparation trumps presumption. And a single person with the courage to stand up for their convictions can change hearts, minds, and even laws. Representative Jasmine Crockett walked into Judge Howell's courtroom as a relatively unknown freshman congresswoman. She walked out as a national figure who had demonstrated that the next generation of American leadership is ready to challenge the establishment when necessary and defend democratic principles with both passion and precision. The key question now isn't whether Crockett's algorithmic justice doctrine will become accepted constitutional law. Early indications suggest it will. The question is, what other established assumptions about American law and politics are ready to be challenged by leaders who combine deep expertise with the courage to stand up to institutional pressure? As the story continued to ripple outward, Crockett's influence only grew. She was invited to speak at universities, legal conferences, and civil rights events across the country. Her story was featured in major magazines, and her approach to advocacy became a case study in law schools. Young women and aspiring attorneys wrote to her by the thousands, sharing how her refusal to be silenced inspired them to pursue their own ambitions. Crockett responded to as many as she could, always emphasizing the importance of preparation, integrity, and never letting anyone else define your worth. Meanwhile, the legal world took note. Judges across the country began to reconsider how they handled novel legal arguments, and law professors updated their syllabi to include the Crockett-Howell hearing as a model for effective advocacy. The media, too, began to shift. News outlets started prioritizing substance over spectacle, knowing that audiences were hungry for real accountability, not just viral drama. The Crockett-Howell exchange became a template for how to hold power to account in the digital age. With facts, with poise, and with the courage to stand tall when it matters most. For Howell, the hearing was a turning point. She became more open to new ideas, more careful in her questioning, and more willing to admit when she was wrong. Her colleagues noticed the change, and some even credited Crockett with helping to usher in a new era of judicial humility. As the dust settled, the legacy of that day in the courtroom became clear. Jasmine Crockett's words didn't just wipe the smile off a dismissive judge's face. They opened the door to a new standard for public discourse. They reminded America that courage, preparation, and authenticity can change the narrative, shift the balance of power, and inspire a generation to demand more from their leaders. And so, as the world watched, a single moment of defiance echoed far beyond the walls of the courtroom. It became a rallying cry for anyone who's ever been told to sit down, to wait their turn, or to stay quiet. Jasmine Crockett's reply was more than a comeback. It was a promise that the future belongs to those who stand up, speak out, and refuse to be silenced.